Considered the nature and circumstances of the offense. I have considered the aggravating factor found by the jury. I have identified aggravating and mitigating factors and considered those factors in arriving at a sentence for Ms. Arias. As aggravation, the court finds, as the jury found, the crime was especially cruel. The offense was committed with at least 2 deadly weapons, a gun and at least 1 knife. The crime involved substantial planning and preparation. The defendant did not render aid to the victim. The defendant destroyed evidence at the crime scene. The defendant went to great lengths to conceal her involvement in the crime. The court has also considered, as an aggravating factor, the emotional and financial harm to the victim family members. As mitigation, the court finds the defendant has no prior criminal history. The defendant has family and community support. The defendant has mental health issues. The court has also considered the defendant's childhood background, family history, and her expressed remorse. The court finds the mitigation presented is not sufficiently substantial to call for leniency and that a natural life sentence is appropriate. It is ordered the defendant shall be incarcerated in the Department of Corrections for the rest of her natural life with no possibility of parole. The sentence shall begin today. The defendant shall receive credit for 2,463 days of pre-sentence credit. It is ordered the defendant shall pay a $10 probation surcharge assessment. And as previously stated, the court is retaining jurisdiction over restitution. Ms. Arias, you have 20 days from today to file a notice of appeal. You have the right to have an attorney represent you. If you cannot afford an attorney, one will be appointed for you. If you cannot afford the necessary records and transcripts, they will be provided for you at no cost. Do you understand?
Yes.
Counsel, is there anything else for the record?
No, thank you.
No, Your Honor.
Your Honor, I would be moving to withdraw at this point in time a reconsideration of April 4th, 2011. That order contemplated joint representation because it was a capital trial pending trial at that time. Given that that is no longer the case, Ms. Arias has been sentenced to life moments ago by this court. I see that there's a few ancillary issues remaining, but the motions for which motion should be filed. But pending that, I would ask that I be withdrawn from restitution hearing or any future matters, particularly given Ms. Arias' choice to be non-communicative with me. I believe it would be best for Ms. Wilmot to handle that, and so I would ask that my motion to withdraw be granted here this morning.
All right, the motion to withdraw is under advisement. Anything else? We are adjourned.